Sam Altman is back as the chief executive of OpenAI.
Sam Altman was ousted from ChatGPT and then hired by Microsoft. The employee staged a coup and he's back again. In this video, we're going to be exploring what legal provisions could have been relied on by the board to kick Sam Altman out in the first place. Hi, my name is Rachel. I'm a startup lawyer, and in case you don't know who I am, I graduated in King's College with first class honors in law in 2013. I worked for the top tier international firms for 7 to 8 years, and I've started a startup practice. So a first big disclaimer is I'm a Singapore qualified lawyer. So when we're going through the documents, we're going to be looking at it from a plain English perspective. The first country we're going to visit is the United States, where Sam himself was kicked off the board. And the document we're going to be looking at is the document entitled NVCA Voting Agreement. Now, for this agreement, we really want to focus on the board composition mechanisms because that's where the will happen. 1.2b gives founders or negotiating parties two options. The first one is a common director can be appointed, being an individual who is designated by qualified key holders holding a majority of common stock held by qualified key holders. Now, qualified key holders would be a defined term within the document, and it could perhaps refer to the founders, for example. The second thing is founders are usually the ones holding common stock, or what we know in Singapore as ordinary shares. So if Sam Altman's company had a clause like 1.2b and they chose the first option, then he could be kicked out from the board if the majority of the people who constituted the qualified key holders decided that, hey, instead of you being on the board, we want someone else. The second alternative that has been provided is, as a common director, you can be voted in on the board for so long as the director remains an employee of the company. What I would probably do is I would rely on the terms of the employment agreement, find a way to terminate his employment agreement and say, hey Sam, you are no longer an employee of the company and therefore I'm going to kick you out. Now let's look at 1.2c. Now this is really the saving grace because they say as the other common director, the company's chief executive officer shall be appointed on the board, provided that if for any reason the CEO or director shall cease to serve as the chief executive officer of the company, shareholders can vote to remove the CEO. Now, you would think that clause 1.2c solidifies your position as the CEO on the company and on the board, but actually it may not be so straightforward because the clause reads, provided that if for any reason the CEO director shall cease to serve as the chief executive officer of the company. So I'm going to go back to the employment contract and look at the termination provisions. And if for any reason they want to terminate you, or if for any reason you are kicked off the board, you will no longer be able to hold your position on the board as a CEO. And if you want to perhaps protect yourself, you could say that provided that if the CEO is dismissed for cause, with a capital C-A-U-S-E, and define cause very narrowly to say that, okay, if you were jailed, you're bankrupt, or you had too many sexual scandals, you can be kicked off the board. But if you resign or you're forced to resign, then perhaps you might want to amend the clause to say that provided if the CEO ceased to serve as the chief executive officer of the company for cause. And that would save you a little bit of heartbreak. The next country we're going to go to is United Kingdom. In England and Wales, they have released the BVCA documents, which is their equivalent standard form startup documentation, which is very much more aligned with the Singapore common law provision type of drafting. Now, in this shareholders agreement, what can I rely on to kick a founder off? Obviously, the first clause you want to look at are the provisions relating to the board. Clause 4.2 states that for so long as investors hold shares in the company exceeding a certain percentage, they are entitled to appoint a representative to attend as an observer on the board. Observer seats are very different from board seats. So as an observer, you can sit there. You can just be the telltale person like, oh, this is what I heard during the board meeting. But you're not actually entitled to vote. And the end of 4.2 states quite clearly that investors appointed observer is not entitled to vote. Which means that if you sign the BVCA document and you look at 4.2, you can't really use that to kick Sam Altman off. You can only just say that Sam Altman is doing something naughty on the board, which I'm not sure whether he did, and then report back to your investors. So it does seem to me that this document seems to assume that if an investor will be appointed on the board, they're relying on the articles of association that the company has adopted, and they haven't really enshrined it in the BVCA document. So that's really interesting for me. The next provisions I would rely on and probably consider will be Clause 6, which is what I think we normally know as reserve matters, but now it's called consent matters in this document. This clause basically states that there are certain things that cannot be done with the investor majority consent, so that's shareholders, or with the investor director consent, so if an investor director was appointed in accordance with the articles. This does not really give them the ability to kick someone out because it says that you can't do a positive action. For example, you can't appoint a certain person without investor majority consent. But it doesn't really give them the power to say, hey, I will kick you off the board. So it's a veto right. It is not a positive affirmative action right. Now we're going to move on and we're going to travel to Singapore, my favorite country because I'm from Singapore. So in Singapore, we have the VIMA documents that have been formulated by SVCA and SAL. And the provision that I would zoom into would be Clause 2 relating to Board of Directors. Now, I like 2.3 because it says that the founder shall have the right to maintain and appoint in office X number of folks. I like it because this right of appointment is tagged to the founder himself rather than in the first document, which is the NVCA document. You saw that right was tagged to qualified persons, and obviously you cannot rely on 2.3.1 to kick yourself off the board. So the founder can kick a co-founder off, but not the founder himself. So Sam would be safe in Singapore. But one of the things that was mentioned was that it caught him by surprise. That's when you as founders might want to start thinking about things like clauses 2.4.3, which says that the company must give notice to each investor director of X days before the board meeting is held. Now, you as a founder can start thinking like, hey, rather than just extending this invitation to the investor directors only, maybe this notice requirement should be extended to every director, and that would create a more equal playing field. So the next provision I'm going to look at is Clause 6 on reserve matters. And similar to the consent matters that's under the BVCA, it states that certain items cannot be passed without the Series A majority consent or with the prior written approval of the simple majority of the board, and including the investor director consent. Now, previously I said that these are probably veto rights, but at the back, behind the scenes, what could be happening is A, if the majority of the board really wants to kick someone off, they can hold a meeting, make sure the quorum requirements are met. But this is a bit more complicated, as you can tell from my hair flying everywhere, because you need the majority of the board to be aligned with you. And only if the majority of the board is aligned with you and the quorum requirements are met will you be able to conduct a meeting to throw someone off the board. Another thing that I was quite surprised by the Sam Altman incident is the fact that he could join Microsoft to do something so similarly, so quickly. Now, I would have thought that most founders would have a non-compete clause pegged to them. Perhaps Microsoft would be more than happy to pay Sam Altman's non-compete breach off. But given his high demand and ability to create wonderful things, it seems that that will be a pretty high price tag. So this is total information overload, but I've only covered a couple of provisions within the shareholders agreement that investors or even your co-founder could use to kick you off the board. Now, there are other template documents available, like in Australia, we have the AIC document. In Canada, they've also got their startup-friendly documents. And you can see that every shareholders agreement interplays with your rights as a founder differently. We hope you enjoyed this video and you found this information overload really helpful. If you like this video, remember to like, share, and subscribe, and see you next time. Bye!